You're live, Judge.
Okay. Let's go on the record on cause number DC 194598, Weimer versus Sadagian. Counsel, make your appearances.
Gene DeBose for the plaintiff.
Shabazz Nizami for defendants.
Okay, let's go ahead and proceed.
Judge, I wanted to ask you something real quick. There is a litany of objections we've made to the plaintiff's summary judgment evidence. And my understanding is, I know you said we may only have about an hour, maybe more so less. I haven't talked about this with plaintiff's counsel, but maybe we could just go over the rulings on the objections for now and then come back another day on the merits of the motion just for the sake of time. Because I don't think 1 hour is going to be enough, Your Honor, to be honest with you.
Did you provide me a checklist order for the objections?
I have not, Your Honor, but I can get that filed with you today if, after the hearing.
Yeah, so let's deal with the merits then, if you didn't provide me a checklist order, and then we'll go with the objections at some other time.
And I have responded to that, Your Honor.
I'm sorry?
You have a written strike. Actually, you've got massive documents because the other side asked for full transcripts of a couple things I've excerpted. It's the longest thing I've ever filed. It's about 300 or 400 or 500 pages long. I don't expect you to read all that, Judge, but when he objects to it, I got to put it in.
Okay. Let's go ahead and proceed, guys.
Well, that's the thing, Your Honor. I did want to object to the late filing by plaintiff's counsel on those transcripts. They were filed late, and there was no motion for leave that accompanied those transcripts. And so I want to get a ruling from the court in regards to those transcripts as being untimely and see if we can get those struck.
Judges, I understand the law on that. When there's an objection to evidence, you get to put in more stuff to respond to it. I was not going to put, again, 500 pages of material in. And I think it's stuff they have already. I know that the transcript of Mr. Sadigian, it's a case that's on appeal to the Supreme Court. They've got the whole transcript there. I don't know if they got a transcript of the hearing. But again, my understanding of the law is when there's an objection to evidence, you get in to respond to that.
Well, Your Honor, in the motion and the response, plaintiff's counsel does refer to these testimony from these transcripts, and it's only later after the objection did he file the actual certified copies of the transcript.
Oh, yeah.
And that was filed late, and there was no motion for leave on file with the court and filing those evidence late.
Well, I don't know what late is. I got the objections on Friday, and I cranked out a whole mass of stuff yesterday. I couldn't have, well, anyway. Again, my understanding of the law is that when there is an objection to a formal objection to evidence, that it may be corrected by additions to the body before you. And again, I wouldn't put that in if I didn't have, if he didn't object to it. I was surprised at the objection.
So the only thing that's added in it is just to provide complete transcripts, or is there anything else?
No, I have filed two responses. One, a first one, which is just those transcripts. I want to get it off my desk. Then as to the specific objections, I filed a second response. Neither of those, and I think Mr. Nizami's objection, neither of those have passed muster yet and been accepted as filings.
Well, Judge, the response that was due 1 week before the hearing refers to these transcripts, but these transcripts were not on file at that time, so they're late filed summary judgment evidence. And the rules specifically say you have to file a motion for leave to file late filed summary judgment evidence, which has not been filed in this case.
Did you file a motion for leave?
No, Your Honor. Again, my understanding that you do not need to do that when you are responding to an evidentiary objection.
I know you can do that with affidavits.
Well, these were objections. Well, the second response responds to the specifics in the affidavits. The other thing, I mean, it's really formal. I know they've got the transcript of Mr. Sadigian from the trial over in the 101st. I'm assuming that they have a copy of the transcript so that this is. And
Judge, that's from a separate case that's not related to this lawsuit.
doesn't matter. It's relevant statements under oath by your client. And there was no objection to that. The only objection was that you didn't have the transcript. But I know you do. I mean, not you necessarily. You're not on that case. But Mr. Sadigian certainly has it. Because what I sent you, you probably noticed, was
again, Your Honor,
from the appellate record.
The burden is on the plaintiff to file summary judgment evidence, and he did not file these transcripts in a timely manner per the Texas Rules of Civil Procedure.
I filed excerpts from them, which are accurate and true. And I had an affidavit that said these are true and correct excerpts from the transcript.
So I think what you're thinking about is 166AF, which says defects in the forms of affidavits or attachments will not be grounds for a reversal unless specifically pointed out by objection by an opposing party with the opportunity but refusal to amend. I think, is that what you're getting on about being able to supplement?
Yes, I mean, I had that. If I missed a step, I worked on this about 10 hours yesterday. If I missed a step, I'm sorry, but that's what I was aiming for.
So, as I understand it, you're objecting to some of his affidavits and attachments, and then he has supplemented those affidavits and attachments, which would seem to be allowed by the 166A. This supplement of the transcript, I'm not sure really matters because I don't think he has to provide the whole transcript, but does that address everything?
No, Your Honor. The issue was that the evidence provided in their response referred to deposition testimony, and there wasn't a certified copy of that deposition transcript until yesterday, until Sunday evening, and so that's what my objection is.
I'm not sure the certified certifications. So certification's the only issue?
Yes, Your Honor, because the actual transcript weren't provided. It was just like a summary or a type out of the testimony that the plaintiff was referring to in his response. And then the actual certified copies of the transcripts were provided for verification until yesterday, until Sunday evening.
I think the rule covers
You
it.
provided, did you, what, okay, maybe I misunderstood. Did you provide okay, I thought you had provided certain pages out of the deposition, or did you just provide, what exactly did you do?
What I did is I took a copy of the testimony and typed that into the body of my motion. I had an affidavit of mine saying that that testimony was true and correct copies of testimony from the two sources that they were coming from. And frankly, I think that would have been enough.
You didn't attach the actual deposition pages?
No, I did. No, I did not. I didn't. I suppose I could have. I suppose, but what they objected to is they wanted the full transcript with all the certifications. So I provided the whole thing. The certification page is a wholly different page. But again, I think that falls within the rule. This is a technical objection. Does not change the substance at all of that particular aspect.
Your Honor, if I may, had plaintiff's counsel attached the relevant portions of this transcript along with the certification from the court reporter, this wouldn't have been an issue at all. We would have been going forward, but that's not the case, as you just heard from Mr. DeBose. He did not file the actual copies of the transcript as part of his response a week before today's hearing.
And this is a new one. I have to admit, I've reviewed hundreds and hundreds, probably thousands of depositions. I've never seen anyone do it that way, or you you didn't attach the pages out of the deposition. That's what I thought had happened. You'd attached just some of
No.
the pages, but not all the
No,
pages. You didn't attach any of the pages.
No, I didn't. There are only a couple of pages, but again, I think, I copied them. I said, these are true and correct copies of that testimony. It seems to me that that should suffice. He then objects, so I give him the whole thing. It really does not change the substance at all of what was there.
It's a procedural issue, Your Honor, not a substantive issue.
Were the deposition?
It's not a deposition, Your Honor. These were trial proceed. One was from the motion
Okay,
for
you're
temporary
answering-
injunction in this case,
Mr.
and the
Michelle,
other was trial testimony in another case.
You're actually answering the question before I ask it. So
I'm sorry.
Let me go ahead and ask the full question so you know where I'm going with this. So were these deposition, whatever you call it, summaries or however you put it, were they attached to an affidavit or did you just provide a summary or how were they?
Attached to my affidavit was
Attached to your
a typed out version, not the original pages. And in that affidavit, I said, these are true and correct copies of the testimony. And one of the reasons I did that is just to compact it down to a smaller volume.
Again, Your Honor, what he did was he typed it up and then attested that this is a true, correct copy of the testimony. But this testimony that he attached to his motion was his own product. He typed it up himself. And
Well, no, it's actually, I took a copy.
Wait. So 166AF says that he has an opportunity to amend an affidavit or the attachments to an affidavit. Again, this is, I never think that I could find new things with summary judgments because I've done so many, but to me, what he did is these were attachments to an affidavit. You've objected to the attachments. He has a right under 166AF to amend the attachments. And so I guess that's, it's a strange way to do it, I guess, but I think that the rule covers that unless you have some case law to the contrary, which I would be surprised because I've never seen anyone do it this way.
Me neither, Your Honor. That's why I objected to it. Again, he's not attaching the actual copies of the transcript. It's just more so his own.
You're objecting to the form of the attachments to the affidavit. He has the right to amend the affidavit and also the attachments to the affidavit. And so, and it doesn't say that he needs to seek leave under Rule 166AF. So I'm going to allow him to the extent that there's objections about the forms of the affidavits or the attachments to the affidavit, I'm going to allow him to do that. So let's get to the merits.
Thank you, Your Honor. And then one more thing, we're moving for no evidence motion for summary judgment. And so really, depending on how the court rules on our objections, that will attest to whether there's enough sufficient evidence to grant a no evidence motion for summary judgment.
Is that your entire argument on the merits?
No, Your Honor. I have more on the merits if you wanted to proceed that way. Okay. Your Honor, this is a claim for a bunch of different sorts of claims, one regarding property here in Dallas County. I'll just cut straight to the chase. There is one of the claims is for breach of contract. And the issue with that is that the contract was never formed. And there were certain, if you look at the evidence and the contract that the plaintiff is claiming that was breached, there was a condition precedent that was supposed to be fulfilled and it never was. And plaintiff admitted to that. He had to deposit about $3,900 as a deposit. He admitted he did not give that $3,900 deposit in full. There was also a condition subsequent as well to that contract in which the plaintiff was supposed to give $8,000 from a tax credit from the government back in 2008. He also admitted he never even applied for that and he never gave that credit as well to the seller. So the plaintiff is not suing my client for breach of contract, but there was no contract formed because of those issues right there. And we moved for affirmative defenses on those two issues for for lack of consideration and for failure for conditions subsequent. And so we want the court to rule on our affirmative defenses and grant a summary judgment in our favor on the breach of contract claim. And I'll let plaintiff's counsel respond, and that can be right after.
Okay, response.
Let me tell you what the story is here. In 2010, my client, Mr. Weimer, was living in a drug-infested apartment building with his wife. He and his wife had both been addicts, but while he was in prison, he got clean. They wanted to get out of that apartment. If you know much about addicts and getting out of it, and I've been around a lot of them in recovery, it is death to be surrounded by people who are using. So they went out and they looked for, they were looking for a new place to live, and they saw a house, had a sign in front of it, said for rent with a phone number, and they called and they got Mr. Sadigian on the phone. And in phone calls, it must have been, they worked out a deal because he was renting the house, but he told them that if they wanted, they could buy it. So they asked, well, how much would that be? He said, well, if you're paying cash, it'd be $45,000. If you were going to pay it out, it's going to be $89,900. And that sounded like a pretty good deal to them. Neither of them had ever owned a house. Neither of them had ever borrowed money to buy a house. Neither of them knew anything about mortgages. So they went and they met Mr. Sadigian, who had a pile of papers that he had prepared ahead of time. And he repeated that that was the deal. And how they were going to pay that was they were going to have a lease of which they will pay $795 a month. And that money will be applied to the purchase price of the property. Excuse me, my phone's doing bad things here. I'm sorry. I have shut it off before, but okay. Mr. Sadigian wanted a $3,900 deposit. They gave him about $1,700, and they had looked in the window of the house before when they first saw it, and they could see that it needed some work to be done. So they said, look, we don't have that cash, but we can fix the house up. Will you take that in satisfaction of the remainder $3,500? Mr. Sadigian said yes. He gave him a whole stack of papers to sign. At present, we have 10 pieces of paper that they signed there. He gave none of them, those pieces of paper to them there. He only had one copy, he took it away. And his testimony at the hearing was, it was his rule not to give those pieces of paper to anybody. But somebody in his office faxed them some of the documents that they'd signed. They faxed them, one, a lease document, two, a settlement document that said they were buying the house, what the house was, what the price was, and says that it is a memorandum of the contract. And they gave him a couple of other things. In reliance on Mr. Sadigian's promise to accept the work in satisfaction of the down payment, they went in, and when they walked into the house, they didn't get a key until after they met with him. And it may have been one of those boxes you open. When they walked in, they found out the house was a disaster. One of the guys who was with him stepped on the floor and went right through it. But because they were buying the house, he spent about $17,000 fixing it up. It took him, I think, 2 weeks of 3 or 4 guys, him, Mr. Weimer, and some of his friends, to get the house to where it was operating. They had put in new plumbing, pipes leaked. It was a disaster. And Mr. Weimer had said, if we were just leasing it, we would never even have lived there, much less do all that work. So they continued to make their payments, the $795, believing all along that it was going to pay for the house. And this went on basically for many, many years. At one time, Mr. Sadigian raised the price, and Mr. Weimer said, you weren't going to do that. He said, well, no, I'm going to do it. Now, the good side of that for Mr. Weimer is it's going to get paid off sooner. But he went along, assuming it was there when they had problems with the roof of the house. They put a new roof on. I think that was about $7,000. Put a lot of money into this that a tenant is not going to do. And they went on with this belief that they had a transaction. And they had 4 pieces of paper that they had, and they are attached, that had been sent over to them. But there was nothing in those 4 pieces of paper that they had signed that was in any way contradictory of the deal that they believed they had with him, which was where all the rent's going to pay the house for the house. It's a rent-to-own deal. Now, he doesn't know anything about rent-to-own. He was desperate for property. And actually, he didn't do the dealing with Mr. Sadigian. His wife did all that. She is now deceased. And then Mr. Sadigian, because when he raised the rent, Mr. Weimer just couldn't pay it. So he moved to, filed an eviction. And in that, when they go to the eviction, and this is last February, this is a matter of weeks before the suit was filed. While they were there, Mr. Weimer, when he got before the judge, was going to say, hey, judge, I'm buying this house. Now, if he had said that, the judge would have dismissed the case because it raises a title issue. He had no idea about that. But while they were there, Mr. City, and all this stuff is in affidavits that are before the court. While he was there, Mr. Sadigian said, hey, let's work out a deal. You give me $2,500. I'm going to let you stay in the house. You're going to own the house. I'm not going to throw you out. They went back to his house. Mr. Sadigian looked at the house. He had not been there before. He thought it's a livable house. I've been in it. And then he said, okay, I'm going to redo the whole deal. And you get me the $2,500 and we're going to be good going forward. The next thing that Mr. Weimer knew was that a deputy was beating on his door saying, we're throwing you out. By chance, I met him. And because I've seen this process for Mr. Sadigian in another suit, in fact, a couple of other suits that I've got against him, I looked at that and I said, this is a bad deal. He is messing with you. We had expedited discovery, and we got the other papers that Mr. Sadigian had not sent to him. And one of those was a piece of paper that showed that he would have to pay $8,000 50 days into the deal that he had. This was the note. He didn't have the note. And that it was a note with a 2-year term. It had a balloon on it at 2 years. It had increased payments during the second year of those 2 years. And at that time, Mr. Weimer realized Sadigian was not about ever to sell him the house. He was just getting him to fix up the house so he'd get some rent out of the house. Probably he decided not to do the deal with Mr. Sadigian. I don't know if he ever would have. I think he wanted to go to Mr. Weimer's house just to see what kind of condition it in, whether he could rent it out. And he decided he could because of Mr. Weimer's work, and so he decided to go ahead and throw him out. In any case, at that moment, for the first time, he realized that this had been a deal to throw him under the bus. Now, Mr. Nizami had mentioned something about a tax credit he was supposed to get. Trust me, Weimer doesn't know anything about tax credits, but he signed every piece of paper that was there because Sadigian said, you need to do that. Well, that particular document, which is actually one of the documents delivered to him, he didn't know what it was. It said it had to be performed by April 15th. Well, he didn't sign the document until April 20th. He couldn't possibly perform it. The other thing is that tax credit, and I have this, the legislative enactments in my response, that tax credit had expired on April 30th of that year. So when he signed it on the 20th, he couldn't get that. And I suppose the $8,000 was supposed to be that, that tax credit. He might not get that till the next day. He didn't know anything about that. But it was a document that I think our expert will say was just put there to give him an excuse if he ever wanted to throw my guy out. One of the pieces of paper he signed at that pile, he didn't get it, but was a deed in lieu of foreclosure. He's just signing the documents. When I told him, that piece of paper, if you're buying the house, all he has to do is go and put it in. He does not have to do anything, and you're out. You no longer own the house. He said, my God, if I'd known that, I wouldn't have signed it. Things were not explained to him. And we have an expert who's done between 7,500 and 10,000 owner finance deals. And she said this was a travesty. There was no information given to Mr. Weimer that you're supposed to get. There's supposed to be some delay periods. It didn't happen. It was in her mind, she said, a deal like this is a fraudulent deal. And she particularly focused on the form of the note. And her testimony was it was designed to fail because there was no way that Mr. Sadigian could come up with $8,000 in a month or two. And Mr. Sadigian never asked, what kind of money he made, but he did know that they were basically broke because they told him they didn't have the money to pay the $3,900. So Mr. Sadigian gives his note to sign. He knows that's a note they cannot perform. Now, the deed in lieu of foreclosure, and Your Honor knows what these are. People are getting foreclosed on, and a lender may give them the opportunity to get out of the property without having a foreclosure, and they'll allow them to sign a deed in lieu of foreclosure, and then it goes. But you don't give that to people at the beginning when they're doing their deals. Now, our expert went out and did a little research, and she found 3 instances where people had purchased properties from Mr. Sadigian, and they lost the property through a deed in lieu of foreclosure. In all 3 of those cases, the date on the deed giving them the property was the same as the deed on the deed in lieu of foreclosure. This is his practice in dealing with people who are vulnerable. My other client couldn't read English. These are the people he is after. But they, on the deed in lieu of foreclosure, all the other documents they signed have a typed date. On the deed in lieu of foreclosure, it's a handwritten date. It's handwritten in the notaries section and on the first page. And Mr. Sadigan has said, well, he came back and signed this, he and his wife. Mr. Weimer's testimony is, no, we were there. We met him once. As a matter of fact, I don't think Mr. Sadigan and Mr. Weimer met face to face until they were in the justice court for the eviction. And Mr. Sadigan had never been in Mr. Weimer's house, never that we know. He didn't go in at the time of that they moved in. He never came. I mean, he could have snuck in, but I doubt that he would do that. Never came into the house.
But I'm sorry. I should just, you're kind of going on and on.
Thank you, Judge.
Well,
so let me just kind of,
okay.
wait. I gave you a long time to talk. You need to let me talk, please. There's a number of causes of action here, so we kind of need to roll on that. Did you provide me a checklist order, defense counsel, on this?
No, Your Honor. I don't think, actually, not a checklist order. I've not, Your Honor. Just a general order denying, granting, I'm sorry, our motion for summary judgment.
Okay.
My response goes through with specific heading
Right.
on each one of his objections. He objects to, and let me pull my thing up here.
Judge, if I may, there's one thing I think we can discuss right now that's pretty relevant that could probably knock out a lot of these causes of action, and that's the statute of limitations issue. As you're aware, as defense plaintiff's counsel mentioned, these causes of action accrued back in 2010. The lease agreement that the plaintiff is referring to, that the purported lease to purchase agreement was signed back in 2010. The deed in lieu of foreclosure, which is attached as Exhibit A4 to our motion for summary judgment, was also signed 3 days later on May 23rd, 2010. That deed in lieu of foreclosure actually references the fact that the plaintiff could not pay the down payment of the $3,900. So they asked my clients to sign the deed in lieu of foreclosure, and that agreement is attached to A4 as well too. And that deed is signed and notarized.
So let me make this is such a strange transaction here. So your client gave him the proper, or gave him possession of the property, but when the deal was done, the defendant, the plaintiff signed a deed in lieu of foreclosure?
Yeah, let me explain to you, Your Honor. What happened was they came to an agreement to purchase the property. And so what my clients did is they gave him these documents reflecting that they agreed to it. When the time came for the plaintiff to pay the deposit, which my client was expecting, that's when Mr. Weimer, the plaintiff, was like, well, I don't have that $3,900. I can't pay you that today. So my client was like, well, okay, you can't buy the property today. Why don't you just enter into a lease, and then later down the road, if you're able to purchase it, we can negotiate a new price or buy the property outright. And that's when the plaintiff was like, okay, he agreed to it. So even though they signed the deed, they signed the contract, it wasn't formalized because the plaintiff didn't give the $3,900. So he went ahead and signed a lease, which is attached to our motion, and he was paying rent on it for several months. And so, and they signed the deed of lieu foreclosure 3 days later because my client, the plaintiff, was worried that my clients could foreclose on it for not fulfilling his obligations underneath that agreement, which was the $3,900. So that's why he went ahead and conveyed the property back to my client underneath the deed of lieu foreclosure, which was signed May 23rd, 2010, which is also the basis of our counterclaim for declaratory judgment on quiet title, to show that that property was actually deeded back to my client 3 days after the signing of the lease agreement.
Your Honor, if I may.
It's very strange, I know, Your Honor.
There were one of the causes of action is under the statute that covers a rent-to-own deals. It's the executory contract for conveyance. Under that statute, if you go into a rent-to-own deal and there's a breach the person who's selling is obligated by statute to give notice to the buyer that there has been a breach. And the buyer is, it has to be by certified or registered mail. This didn't happen. He's saying there's a breach. It didn't happen. And then he has a period he has an opportunity to cure. That was not done. We filed the contract of sale with in the deed records. And under the statute, as soon as you file the contract, you own the property, subject to whatever mortgage lien there is. Judge, this thing has got contested facts at every single level. He talks about the statute of limitations, but those statute of limitations only run once you become aware of what you did. One of the things that most influenced Judge Purdy when she was doing this was that they never gave him the note that showed these outrageous payments that he had to make. No notice given that is required by statute. Our expert went through all the documents and said they're inadequate for a legitimate loan. Now, remember, if a party fraudulently conceals his fraudulent behavior, that bars the running of the statute of limitations. And in this case, why did he he was carrying on as though he was going to sell him the property all along, because at the
That's not true.
fiction, he says, hey, I'm going to keep it going. Judge, there are contested issues of fact at every level in this lawsuit. And it is not
Your Honor, if I may.
appropriate for the granting of a motion for either no evidence or on the statute of limitations. This thing that I wrote is very, very detailed as to the law and as to the facts.
Judge, if I may.
Go ahead.
Your Honor, if you, a couple of things regarding the lease to purchase agreement. If you look at the four corners of that lease agreement, nowhere does it mention anything about purchasing the property outright, nothing at all. And so you got statute of fraud issues, which has been raised, and you also have statute of limitation issues, which also has been raised. Regarding the fraudulent claims by the plaintiff, if you look at the evidence they have presented, you will see they have not given any evidence regarding any material misrepresentation by my client. They haven't attached any testimony from my client regarding such. They've only.
Make sure I understand the sequence of this transaction. So originally, your client gave a deed.
Yes.
To the client, correct? And then he provided a deed in lieu of foreclosure for the property to be transferred back.
Correct, Your Honor. And the reason was he thought he was.
And then he provided a lease.
No, Your Honor. He provided the lease the day that he thought he was selling the property to the plaintiff. When the plaintiff said, I don't have the deposit today to pay you, that is when he said, okay, well, you should enter into a lease. And then later down the road, if you're ready
when was the original deed signed? Not the deed in lieu of foreclosure, but the other deed.
May 20th, 2010. That's the same day as the lease agreement as well, too.
And the deed, all three of these were signed the same day?
No, Your Honor. The deed in lieu of foreclosure was signed on May 23rd, 2010, so 3 days later.
Well, that's a contested issue.
It is not, Your Honor. It's notarized. There's a notary on it, and the notary has 2 dates on it written as well, so it's been signed and acknowledged. It is presumed that it was signed.
And the lease is on the 20th or the 23rd?
Everything is on the 20th. Everything.
No, Your Honor. That is not
except they've got a date that we've contested along. But Your Honor, this is not a straight fraud case. This is a false promise case. We are contending that Mr. Sadigian made this promise he was going to sell it. Why would my guy put $17,000 into a piece of property that he's renting? It doesn't make any sense.
Your Honor, look at the evidence they have presented. They have presented no evidence that my client made any misrepresentation of anything.
Yeah, we've got my guy saying.
Excuse me, Mr. DeBose, I'm speaking. They have self-serving affidavits. You see that Mr. Weimer is testifying that he told me this. My client, the defendant told me this. The defendant told me that. He has no evidence from my client specifically saying anything regarding what Mr. DeBose is talking about because it didn't.
Of course.
And they have the burden of proof to prove that, and they have not met that burden of proof.
Do you expect somebody who's committing a fraud to admit, hey, I committed a fraud?
Yeah, I kind of agree with that. I mean, where else is he going to get it? I mean, if he's.
Judge,
Your Honor,
don't like to take things under advisement, but I really would like you to read my response to this.
I've read it.
Okay.
I don't think it's terribly clear, but I've read it.
Well, the facts are there was by the way, when you have partial performance, it takes care of statute of frauds. Besides, we have a document that is signed that says it's the contract. So the statute of frauds is an issue.
And Judge, my point is that the plaintiff is trying to speak from both sides of his mouth. He's saying, oh, well, the defendant's obligations, I completely understand, and he didn't fulfill them. But my obligations when it came for the contract is, oh, I didn't understand it. I didn't know. I'm ignorant. I didn't know anything.
My guy is.
I'm sorry. I'm speaking, sir. You had your time.
Yeah, Mr. DeBose, yeah, let him speak.
Your Honor, you'll see that Mr. Weimer, the plaintiff, has not presented any evidence from my client saying that he misled him or that he committed any sort of fraud. All he is saying that, hey, he told me this, he told me that. The issue with him saying that is that the parole evidence comes into play. He's trying to bring in outside discussions and things about the contract that are not contained within the four corners of itself. So that also raises a parole evidence issue as well, too, in addition to the statute of frauds. And so what happened is that this was a deal that Mr. Weimer realized later that this was not a good deal for him. He made a mistake because he didn't realize, the financial obligations he was going to have incur in terms of his property. And now when he was about to be evicted, that is when all this lawsuit came in about. He's trying to raise some issues saying, I didn't know, I was taken advantage of because of my ignorance when there's no evidence of such. Mr. Weimer was free to sign this agreement and he could have retained counsel and sought advisement. He did not do any of that through his own volition. That had nothing to do with my clients trying to, there's no issue of coercion or duress regarding this issue. And the fact of the matter is this happened back in 2010. And so the discovery rule doesn't play because the discovery rule says either you knew or you should have known. Mr. Weimer admits that when he signed the lease agreement, he had 10 other lease agreements that he signed into before that day as well, too. So it wasn't the first time that Mr. Weimer was signing a lease agreement. Had he reviewed the lease agreement, he would have saw that, hey, this is not a lease to purchase agreement. This is a straight up lease agreement, nothing about anything regarding the purchase. And the fact of the matter is that when he signed the deed of lien foreclosure 3 days later, he should have known back then that, hey, I don't even own this property anymore. I'm giving it away. I'm deeding it away to back to the original owners of the property. And so again, this raises statute of limitations issues and a discovery rule does not come into play. So at the very least, the court should at least rule on the statute of limitations issues regarding plaintiff's causes of action.
Your Honor, again, the parole evidence rule does not apply in a fraud case. And this is a fraud case. Mr. Sadigian has a lot of documents that he gets people to sign. And he puts it, again, our expert said, this was designed to fail so that if any time he wanted to throw him out, he could. And Judge, Mr. May I talk now? Is it my turn?
Objected to the expert.
Is it my turn? Thank you.
Go ahead, Mr. DeBose.
My client is very ignorant. I had my expert talk to him. He said he's a smart guy, but he is very uneducated and not knowledgeable about real estate transactions. Mr. Nizami is talking. These are the kind of people that
Sadigian
preys upon. People who are
counsel's opinion are
ignorant, who are desperate, and don't know what they're doing. My client says he signed all these pieces of paper because the guy said to sign them. The only pieces of paper he got, I mean, it was, the documents were sent to him later after all this went back. They were faxed over to him after Mr. Sadigian says, "Oh, it's all over." Well, how come they're faxing him the not just the lease, but the lease and the settlement paper and the deed and this cockamamie Mead thing? Of the pieces of paper that was signed that day, the 10 pieces of paper, there's one lease and there are 9 documents that are all about the sale. And Mr. Sadigian never intended to complete that sale.
And Judge, may I point out that,
get the money from him, get the house fixed up.
Judge, may I
At
point
the
out
very least, you know, he's my guy would be entitled to the money back that he put in under his fraudulent promise. Man, a fraudulent promise. You don't think about. He didn't walk out of there and say, "Oh my goodness, this is such a strange deal. It must be a fraud. Therefore, the statute of limitations starts to run." No, he is an innocent. He doesn't know this stuff. And again, our expert goes through that with some detail. This was not a deal that was done that any legitimate lender would do. It's filled with holes, with ways of taking advantage of Mr. Weimer or anybody else who's in his position.
and Judge, we've objected to
Mr. Sadigian withheld the documents that had Mr. Weimer seen them, he would have known that this was not due. If he'd seen that note that required him to pay $8,000 in 50 days, he would know there was no deal, but he didn't. And he went ahead and he put $17,000 of his own dollars and 2 weeks of his work into the house. This, Your Honor, this is a complicated case. It's going to be tough to get across to a jury, but there is evidence on every single issue of all the pleadings. Now, there are a couple of the causes of action that they have not had motions for that are not included in their motion for no evidence. One of them was the declaratory judgment, and the other was the cause of action under the rent-to-own statute, for lack of a better term. So this is something that can only really be settled in trial, because Mr. Nizami is saying, well, this is what was said there, and my guy is saying, no, that's not what was said there. That means that there are triable issues of fact on every single aspect.
Okay, Mr. DeBose, let Mr. Nizami speak.
And Judge, may I point out that at nowhere is the plaintiff claiming that he didn't sign those documents. He admits he signed those documents. In fact, I have attached my request for admissions to where the plaintiff admits that that's his signature on those documents. At no point did he ever qualify his responses to the request for admissions, stating that, hey, that date is wrong, or anything along those lines. He admitted that that's his signature. So at the very least, the plaintiff should have known what he was getting himself into on the day when he signed those documents. There's no evidence of coercion. There's no evidence of duress. There's no evidence that my client took advantage of the plaintiff's ignorance. What Mr. DeBose is saying, that his guy didn't know, and so he should be excused from all his obligations underneath the contract, which is not how the law works.
I don't know that it's that clear. I mean, your client provided a deed and then a deed back at closing. I mean,
no, that's not true.
These, literally, I don't know if I have hundreds, but numerous cases involving closings and problems at closings. I've never seen anyone at closing have somebody sign a deed giving the property from the buyer to the seller. I mean,
well, the judge, it didn't happen that day. That's what I'm saying. It happened actually on May 23rd, and that's reflected in the deed of lieu foreclosure that I've attached as the exhibit. It happened on May 23rd, 2010. And so it didn't happen the same day. It happened because the plaintiff was not able, and there's an acknowledgement actually attached to that deed. The plaintiff was not able to fulfill his obligations underneath the contract on May 20th of 2010. And so he conveyed the property out of caution, I suppose, back to my client so that my client wouldn't foreclose on the property per the deed of lieu foreclosure. And so the deed of foreclosure was signed actually 3 days after their lease agreement was signed, and the purported conveyance is that's on file with the Dallas County real estate records. So it wasn't the same day.
but that's contested. My guy says he met him only once. And that document is very different than all the others. All the others had
Judge,
type
it's
dates.
notarized. It's
That's the
notarized.
only one.
It's
uh,
notarized twice.
It doesn't matter. And
There's
the
a presumption
notary,
that the notary.
Does it say in the, does it say in the lease agreement or in any of the documents that this deed in lieu of foreclosure was intended to substitute for the previous deed?
no.
Yes, Your Honor. In the deed of foreclosure, it specifically says on there. I can share it with you if you would like. You want me to share it with you on the screen?
Sure.
Okay.
My client had no idea of the.
Actually, Judge, I'm sorry, it won't let me do that. It just says the host has it disabled.
Oh,
But
let
if you
me
go to,
go. I'll enable it.
oh, okay,
Go ahead.
okay.
Judge, all these issues are contested, and remember the statute is about taking advantage of the lack of knowledge or skill of somebody, and only somebody. And again, our
Okay,
experts
Judge.
say this.
Mr.
if
DeBose,
only
may I
somebody-
speak? Mr. DeBose, may I speak? Mr. DeBose, may I speak?
Yes.
Judge, I'm pointing to Exhibit A4, and this is the agreement. And you'll see, I can zoom in. Okay, there you go.
Okay, but this is, okay, wait a
yes.
minute. But this says if they're late over 45 days.
Correct. And then let me point to you the relevant part right here. This is the deed in lieu of foreclosure right here. You
How
see the
could they
date.
be late 45 days just 3 days later?
Like I said, they knew that the agreement to sell wasn't consummated because they didn't have the $3,900 for the deposit that was due. And if you see right here, if you zoom in, it says $3,900 not received and no property insurance provided before filing agreed to something here. But if they acknowledge that $3,900 was not received and no property insurance was provided either. And so this deed was dated for, if you see, May 23rd, 2010. And here's the notary acknowledgement for both the seller, the grantor, and
Go back to the previous page. I can't read that.
I know I'm trying to zoom in for you so we can read. It's a little hard to read. It's $3,900 not received and no property insurance provided before filing agreed to rent, before filing agreed to rent only, which reflects what my clients have been saying, that there was an agreement to rent only. There was no purchase of the property.
Can we go back to that handwritten deal that you showed before? You know, the 45-day agreement?
Judge, should I go back?
Could you please go back
Okay, go
to
ahead,
that?
go ahead and go back.
Okay.
Now, you say this refers to put the deed in lieu of foreclosure instead of foreclosure. And this is dated the 20th. So that deed in lieu of foreclosure must have been in existence on that day, because that comment there wouldn't say the deed in lieu of foreclosure. It might say a deed of foreclosure is going to be signed later.
But Your Honor,
I guess the key thing, go back to that, is this is clearly intended to be something that if they're 45 days late, this is to be done if we are late over 45 days. To me, is that if they're late on their payments over 45 days, then they would be able to do a deed in lieu of foreclosure. But that's not what happened here. I mean, this is a mess. I mean, these documents are just a mess.
I agree, Your Honor, but the deed in lieu of foreclosure is pretty clear. It was deeded back to.
I don't think it is clear at all. I don't think any of this is clear. What I would suggest, Mr. Nizami, is I'll give you two choices. One, I'll just rule on this today, which I don't know is necessarily in your best interest. Or if you want to do this, and I'm not fussing with you, but if you want to provide me checklist order for the objections, the checklist order for the summary judgment that goes through each different cause of action, because I haven't really been able to parse through which cause of action should be dismissed and which one shouldn't. I don't mind passing this and give you an opportunity to reset this. I will say that I mean, it's not your fault, but your clients kind of created this mess themselves when they put all these documents together. These are very confusing, even to me, and I'm a judge. I deal with this stuff all the time. Why you would do this agreement to do a deed in lieu of foreclosure, but then you have to have 45 days notice, but then you didn't give 45 days notice, you foreclosed 3 days later. I mean, it's a mess. I mean, I can see why anybody would be confused by this, and it's not, they're not consistent. Documents are not consistent. And so I don't anticipate that I would grant summary judgment on all of this just based on what I've seen. That doesn't mean that I wouldn't grant summary judgment on some of these causes of action and grant some of your objections. But if you want me to rule on everything now, I will. If not, I can pass it.
Yeah, Judge, we'll go with the latter. We'll defer for your ruling based off of the orders that I filled with the court.
Okay, go ahead and file those and reset this for hearing.
We'll do that, Your Honor.
All right, guys. This is a mess.
It's been fun.
Yeah. One way to put it. You guys have a good day.
Yeah, you too. Thank you, Judge.
Thank you.
Are we off the record, Your Honor?
Oh, I'm sorry. No, we're going to the next hearing.
Yeah, I want to get off here.
Oh, okay. Sorry. Okay.
All right, Mr. Gibson, I
there I
believe you're
am.
here for the next hearing.
That's correct, Your Honor. Mr. Harrod will be taking lead on this as soon as he unmutes. There we go.
Done.
That's the first
Good
time I've
afternoon,
seen
Your
Gene DeBose without a hat on, Judge.
Okay. All right, are both sides here on this Capson Development Corporation or Development Group versus Badillo?
Yes, Your Honor.
Yes, Your Honor.
Okay. Let's go on the record on cause number DC 207342, Capson Development Group versus Badillo. Counsel, make your appearances.
David Gibson and Reagan Harrod for the plaintiff. Mr. Harrod will take the lead on this motion.
And I am Lawrence Granite from Tara Law on behalf of defendants Victor, Manuel, and Bodillo individually and doing business as B&H Construction Company and BH Construction LLC.
Okay. Let's proceed.
Your Honor, we brought this motion because we've been seeking the deposition of Victor Manuel Bodillo for at least a month and a half now and have not been able to get dates agreeable to start that deposition. We first requested the deposition after we were asked for the deposition dates of our client, Mr. Keith Davis and the corporate representative of Plaintiff Capson Development Group, to which we said, available at any time, just give us notice and we'll make it available and happen. Also, since we're scheduling depositions, we want to take Victor Manuel Bodillo's deposition. We got no response to that whatsoever. I sent a follow-up email asking for dates, no response whatsoever. So we sent a deposition, we noticed the deposition at a time convenient for us. I forwarded that notification to opposing counsel and said, again, we're more than willing to work with you on scheduling this to a convenient date. But you know, you've kind of taken it out of our hands. No response to that email. Instead, they went ahead and filed a motion to quash and put in essentially that depositions are premature at this time, notwithstanding our prior requests for depositions, because we need additional parties to join this lawsuit. As background, because I think it's highly important, this is a 112 residential lot development in DeSoto, Texas. My client is the one that's developing this, and he hired Victor Manuel Bodillo to do both the underground utility work and the road work, the paving. This project was rocking and rolling and was almost complete under Mr. Badillo until the city notified Capson Development that, hey, wait a minute, this is pretty much all wrong. It all needs to be restarted. So my client was in the horrible position of essentially having $1 million development plus. He's having to restart over and trying to come up with the finances to salvage the project and essentially redo it. We even had a signed admission from Mr. Badillo taking full responsibility for the concrete work, which in response to our motion for partial summary judgment, which we passed on, he essentially said, I don't speak very good English. I did it under duress, which we believe is not credible, but we went ahead and pulled our hearing. Respectfully, the concrete work is one issue of a much larger issue. The concrete was what the defects in the concrete and the problems with the concrete were what resulted in us having to start over essentially. But as soon as the concrete was removed, all of the underground utility work we discovered was done incorrectly. None of it that was done according to the plans. You had fire hydrants in the wrong location. You had the wrong size box culverts and sewers. All of this that the utility work was solely under contract with Mr. Badillo. These third-party defendants that opposing counsel said, hey, we need to wait for them to come into the picture. They have no connection or association with the underground utility work. And respectfully, that is where the bulk of my client's damages come in from, is from the underground utility work. The concrete work is probably a quarter of his overall damages, and we're approaching about $4 million. And the longer this is delayed and he's having to get additional financing and other consequential damages, I mean, potentially he's looking at close to $10 million in damages.
Have these third-party claims been filed yet or not?
They were filed September 16th, 2020. The third-party claims were essentially, well, if there was something wrong with the concrete, upon information and belief, these other parties would have been responsible. One of them was Big D Concrete. They just brought the material, the concrete, to the work site. CNC poured it under the supervision of Badillo's subcontractor, Danny's Concrete, Alejandro Vasquez, doing business as Danny's Concrete. We have already sued Danny's Concrete separately. We have a partial summary judgment against him. That has been outstanding for quite a while now. I've talked to his personal attorney who keeps saying that she's going to seek a new trial, but doesn't. I mean, it's been months and no move whatsoever to be a party to this lawsuit. So to the extent that we're waiting for him, I think we're going to be waiting forever because it looks like he's not going to ever join this lawsuit. CNC has been served, and I'm assuming that their answer deadline is coming up. Big D Concrete. I mean, whenever you have when you're looking at millions of dollars in damages, I can see why the other side is looking to delay. And I think that their whole argument that we need to wait for these other parties is just indicative of delay. They filed our amended petition was filed in July.
Let me talk to them now. Mr.
Sure.
Granite, is that your name?
Yes, Your Honor.
So what's your position on this? And I will tell you, my inclination is probably to order these depositions to take place, but unless you have a very good reason why this has been delayed.
Well, the delay, we're not doing it just for delay. And I'd like to clear up some of the facts that plaintiff's counsel stated. First of all, we never asked for deposition dates. We just advised them of who we were interested in taking the deposition of in a letter, which was a response to a premature Stowers demand that was timed, a time limit on it, which is why we were busy scrambling with that and other cases. We thought depositions weren't really the top of the list right now. They're making demands on us for settlement. Next, following the demand only by a few days was their premature motion for summary judgment based on what plaintiff's counsel has characterized as a signed admission, which there are numerous things wrong with. First, it was produced by plaintiff to make it look like it was on our client's letterhead. The witness who signed it wasn't present when our client signed it. It was presented in the field. Our client speaks Spanish as his original language. I mean, there are so many things wrong with this. To bring this up, as it being a valid signed admission is just.
I guess my main issue is why have you waited this long to file? You have a trial setting on December 1st, is that right?
Well, Your Honor, we have we changed the trial to a jury trial. The date remained on December 1st.
And I know that I don't know if you've heard, but we're starting up jury trials next week or next month. So there is a possibility we could try it on December 1st.
Well, we have been intending on making a motion once we got past these issues to have the case set as a discovery level 3, because this is a complex commercial construction defect case. It's not something that you rush through. There are always third-party defendants involved, Your Honor. And here, these third-party defendants, let me explain to you the situation here. Plaintiff hired our client as a contractor for its 2 specific parts of the construction, the paving and the utilities. He then went and plaintiff himself purchased all the materials. So their complaint that it's a wrong size box underground, it's not our order. We didn't order those materials. Plaintiff himself ordered those materials. The equipment was all ordered by plaintiff. Plaintiff ordered the big deconstruction as well as CNC Texas concrete to pump and to provide the concrete. The concrete, so our client was basically just serving as labor on this, despite the fact that he's been doing this for years and has the skills and knowledge on where to order things, how to order, when to have them delivered, all of that type of stuff. So these 2 parties weren't our subcontractors. They were plaintiff subcontractors. These 2 parties are crucial to the concrete complaints because plaintiffs are making complaints of the concrete mixture being wrong. Too much water in some places, too little water in other places. Plaintiffs are complaining about the way the concrete was not laid by machine. Well, plaintiff himself was ordering all of that, and we actually got approval not to lay the concrete by machine. There's so many things here that need further evaluation and is absolutely necessary to have these third parties.
Philip, let me just make two quick comments here. One is that this case is really pretty new. I kind of remember now Mr. Gibson asked me to set this quickly, and I probably shouldn't have set this quite this quickly, even separate the COVID issues, because this case was only filed, back in June or May?
I mean, I'm sorry, Your Honor.
Mr. Harrod.
It was, I believe it may have been May or June. We filed the First Amendment petition in July. It's really not as complex as it's being made out to be. The issues, I mean, you have utility work that's really the main issue here. I mean, we had raw sewage backing up onto our site. We had pipes that were not installed with concrete. It's not that complicated. The issue, I think, is damages. And the whole point where I was going with the indicative of delay, we sent our prior counsel, the prior counsel in the suit sent a letter informing they said, hey, come inspect this work before we demolish it. That was sent April 2020. We have concrete still sitting on site. They didn't come look on site until August 20th, 2020. We still have concrete that hasn't been tested. So this whole notion that there's third parties that may be somehow responsible for the damage that Baudillo created, they're not even pursuing those. They're not looking and testing the concrete. They're just using this as a way to delay. They filed their third party claim September 16th, 2020. It's taken them over a month to ask for substitute service on Big D. They're just delaying things and dragging it out. I realize it takes some time in these cases, but we're trying to advance the ball, and essentially they're asking for an abatement of discovery.
I mean, even if this was a credit card case, we would usually not try it for 8 to 10 months, and this is we're about 5 months. I mean, I don't blame you for wanting to move the case. I do think it's going a little too quickly, but if you want to take the depositions now, you can. I wonder if it would make sense to kind of delay it.
If I may address that issue, Your Honor, I don't think it makes any sense whatsoever. They've had an answer on file for 4 months. The discovery period opened 3 months ago. We're trying to take the deposition of the principal defendant here. It's time to get this case moving. My client's got right now the client has a $4 million problem. The delay that the insurance company is trying to inject into this case, which is a good strategy, is going to turn this into a $10 million problem. And the sooner we can get this deposition, the sooner this carrier can start to evaluate the claim. That's part of the reason we want to get this deposition done. If all of the issues that Mr. Granite has raised are legitimate issues to inquire into, but the starting point is the main defendant's deposition.
My only point, I don't necessarily disagree with that. My only point is that this case is so new. I mean, it's 5 months old. Mr. Gibson, you were a judge before. You know how long these things take. This is really very quick for this type of case. But if you want to take the deposition now, I don't have necessarily an opposition to that, but I do see that there's a good chance that this would have to be done again when the third-party defendants come in. And I would say that it probably makes sense to just move the trial setting at this point as well.
Yeah, obviously, I understand the trial setting and how trials work in Dallas under the best of circumstances, which we're not in right now. So I'm not
Or under the worst of circumstances. Right
yeah,
now.
Exactly. I'm not taking a position on that, but we would like to move forward with the deposition. And if other parties want to take his deposition again in the future, so be it.
Well, Your Honor, we think that puts us in the position of being prejudiced because we're going to have to, and a total waste of time and money by all parties. We're going to have to produce our clients twice. That's going to give plaintiffs 2 bites of the apple. And unless they're willing to sit there silent at the deposition of the second deposition of our client and pay for the second deposition of our client, because they're rushing this. This rushing the deposition is not going to rush the resolution of this case. It's just going to serve the.
We're entitled to 6 hours of Q&A regardless of when that takes place, Judge.
Indeed you are, but that every other party is also entitled to sit around and hear that Q&A. And to participate in that. And then if we have to do it twice, you get to come back and ask more questions. Well,
why don't we do this? I'm going to order that the deposition take place within the next 75 days. So hopefully the other parties can get into this. And then I'm going to move the trial setting to May, June, July. Do you guys have a thought?
Oh, anytime's fine, Judge. Any chance I could talk you into 60 days instead of 75?
I was
that puts
that's
us into
funny
next
that you
year.
say that because I was thinking of that, but that takes you right into to Christmas. And so I was given the 75 to let them have a little bit of time after the new year if that's needed to allow the other parties to get into the case. So I was thinking 60 to 75, but let's do this. Let's shoot for and the depositions have to be taken by January 8th, which is somewhere between 60 and 75, I think. So these depositions need to be taken by January 8th. Mr. Granite, what are your thoughts about a trial setting?
Your Honor, I've been trying to do that with other cases now, and our office is not available for about a year from now for a trial.
Your Honor, I would suggest May. The Supreme Court, under, again, the best of circumstances, wants the courts to be doing these within a year to 18 months. And the docket is what it is, but if we put this out 18 months, no one's going to work on this case except for us, and my client's going to be out of business by then.
Why don't we do this? I'm going to give you 3 choices. Each of you get to veto one. So I'm going to pull up the trial setting on this.
You know, Judge Genevine used to set deposition. They'd give you a deposition date options, and if you couldn't agree, he'd let his 7-year-old daughter pick them. So this is probably a pretty good approach. She's about 24 now, so it's not quite as problematic.
That is really funny.
Well, you saw how that worked out.
Yeah. Okay, so we're going to look at June 1st, June 8th, or July 13th. Those are your 3 dates. You get to veto one.
We vetoed July 13th.
Okay, June 1st or June 8th?
Your Honor, the lead counsel on this is out of the country on the whole month of June. There's nothing I can do.
Who is lead counsel on this?
Cynthia Tarl.
And is she filed a vacation letter?
I am not certain. I'd have to look.
All right, well, let's move it up then. How about May 11th, May 18th, or May 25th?
I would
I
have
can live with any of those dates, Judge.
I'll let him veto first.
May 11th. What was the middle one?
18th or
18th.
25th?
I'm just looking at my trial calendar for the office and would say it should be May 18th.
That's the one you're vetoing?
No, I would veto the 25th.
Okay. So May, you said any day. We'll just give him May 18th, if that's okay, Mr. Gibson.
Yes, that works.
All right, so we're going to go ahead and set this, reset this for trial for May 18th. Deposition has to take place by January 8th. Anything else, guys?
Is that
No, Your
just
Honor.
plaintiff's deposition, Your Honor? I mean, defendant's deposition has to take place by January 7th or all depositions?
No, just the ones that were moved on today. I don't know which ones were moved on, but the ones that were moved on.
And incidentally, I have a motion pending for substitute service on the two missing parties that
When did you file that?
I filed it when I filed my response to this. I believe we filed and I wanted it noticed from today. So we must have filed it Wednesday, but I think my secretary forgot, and so we filed it for Thursday.
You filed it on Thursday?
No, we filed it last Wednesday to be, and it's now to be noticed, it's notice on submission on Thursday.
So I'm looking at the motion. It doesn't look like you guys filed an order with it.
That was actually an issue I had with my secretary this morning, Your Honor. There is an order. We were instructed to put all of the exhibits together with the motion as one document and file the order as a second document. So it should,
Let me just see. It could be the clerk's misnamed it, so you may be right, but it's listed as a motion, two different motions. So let me see. Yeah, you did. It was misnamed by the clerk. Sorry about that. Okay, yeah, we'll take a look at that today.
Yeah, I'm sorry, Judge. Big D has counsel. I'm not sure why we need to go through this hoop, but obviously he's filed a motion. There's a lawsuit pending. Big D is represented, so that shouldn't be an issue.
oh, they're not a party to this case.
I understand. This goes to the delay issue. We have a motion for substitute service pending against a defendant who's already got a lawyer. And that delay, that inability to serve Big D is being used as an excuse. Your Honor has already ruled. It is what it is. I'm just fussing at this point.
Okay, great. I always enjoy that. All right, guys.
It's easier when you're on Zoom than when you are in person, I can assure you.
You guys be safe out there, and we'll review the motion for substitute service and try to get you an answer by tomorrow.
Sounds good. Thanks, Judge. Appreciate it.
You guys
Thank
be-
you, Your
You
Honor.
guys be safe.
You too.
Oh my God. Come on.
Okay. All right. I'm about to take a break, but did you guys have any questions?
Judge, you're still on YouTube.